Good afternoon, everyone, or good morning. Welcome to the Centre for Legal Innovations webinar series. We're delighted to have you, and most particularly delighted to have John Chisholm, Liz Harris and David Wells with us today from Innovim. The subject, as you can see, is lawyers pricing for humans, gaining a competitive advantage by using options and understanding value. It's a critically important topic and one that's on the minds of everyone, I am sure. On that note, over to you, John, Liz and David.
Thank you, Terry. Welcome, everyone. Good afternoon for those that are in Sydney and Melbourne, and good morning if you're in Western Australia, South Australia and Queensland and wherever else everyone's from. I'm John Chisholm, and together with my colleagues Liz Harris and David Wells, we welcome and we're delighted to be presenting this about pricing for humans. And it's called pricing for humans because, notwithstanding AI and tech and robots and computers and that, most of your purchases, I imagine, are humans. Certainly the sellers are humans, and it's humans that buy and sell services. What we're covering today is basically what is value. Very interesting. How do clients make purchasing decisions? The power of options. And we're going to spend a fair bit of time on options today. And also, how can we influence our clients' purchasing decisions? We won't spend much time on this. Hopefully, you know, I'm the recovering lawyer here. David and Liz are both real lawyers, practicing lawyers still. But yeah, we're joined together, as you know, the Innovim Group, and we're pretty passionate about not just pricing for pricing's sake, but because if you change your pricing model and change your business model, it's just amazing things what good lawyers can do and the value they can provide to their clients. Some of you have probably seen this, the great Peter Drucker. I think he said this probably back in the 50s, but no customer ever buys a product nor a services actually. By definition, the customer buys the satisfaction of a want. It was the 50s when he wrote this, buys value. And that's really what we're talking about. We all buy value every day, whether we think about it or not. You would have seen this, the old drill analogy. And as lawyers, are we selling the drill or are we selling the hole? Or perhaps maybe even, are we selling something more than the hole? And Liz and David will elaborate on that. And perhaps I'm stating the obvious, but value is subjective. And we all see value differently, just as our clients do. We all have different perception of value. And as humans, that's what makes us so interesting and confusing at times. And value, the best we can do as lawyers and sellers of legal services and products is influence our clients' perception of value. At the end of the day, your clients are going to make a decision about their own perception of value. And quite frankly, if your clients don't understand the value you're providing to them or going to provide to them, it's not their fault, it's our fault.
So as John has said, the fundamental aspect that we need to understand is that value is the client's perception, not our perception. And that's one of the challenges for us. There's a simple equation about what value means. So clients' perceived value equals their perceived benefits less their perceived costs. And as we'll see, when we're talking about costs, we're not just talking about financial costs. And if we have a better understanding of what the client sees as benefits and also what the client understands as costs, then we actually can increase their perception of value and increase the value that we actually deliver. There are broadly 4 elements of benefits. The outcome. Now, what is the client expecting the outcome is going to be. And it's surprising how often there is little discussion at the outset of a matter to ensure that the lawyer and the client are on the same page about what the client's perceived and expected outcome is going to be. I often use a litigation example. If a client comes to me and says they are owed $100,000, I could commence proceedings and go and try and get a judgment. But if the client comes to me and says they're owed $100,000 and they're in really straitened financial circumstances, and if they could get $50,000 within 30 days, that would save their company, and that's really what they're wanting to achieve. Unless I understand that, proceeding to issue proceedings and going to judgment is going to actually deliver an outcome to the client that they're not going to be happy with. So it's that fundamental agreement at the outset. Another part of the benefits is the client's expectations regarding the experience, how they're going to work with you, what that's going to be like. Third aspect is personnel. Who are they going to work with? Who in their organisation is going to work with you if it's a corporation, for example? And then we can't discount that emotional aspect of benefits. So let's look at each of these a little more closely. On the screen now, you'll see some of the tangible and intangible outcome benefits. Tangible benefits are obviously much easier to identify and quantify. But we often as lawyers don't talk about how we are contributing to the client's profit improvement or improvement in revenue, how the work we might be doing is actually resulting in reduced costs, avoidance of costs. And then we talk about some of the more intangible outcome benefits, such as effectively providing insurance because of the way you've actually drafted a contract, minimising risk, brand protection. You know, all of the intellectual property work that we do is brand protection, but sometimes brand protection comes into play in, for example, litigation by avoiding PR disasters. We don't think about the benefits in those terms and in that context. If we can start to articulate benefits in the way the client would talk about the benefits, it improves their perception and understanding of the value that we're delivering. Emotional benefits, as I said earlier, are often the sorts of benefits that as lawyers, it's too touchy-feely to talk about these. But again, you've got up on screen examples of the way clients themselves have described the benefit that their lawyers are delivering. Classic examples in family law, for example, are a client saying, I felt my lawyer had my back. I felt I had someone in my corner. Very important for a client who is in such a difficult position. But even in more standard matters, less personal matters, you know, a corporate client talking about helping secure a future or vindicate a decision, those are part of the emotional benefits that a client receives. We sometimes underestimate the client's expectations about the experience that they're going to have with us. And again, remembering that value is contextual and will differ for different clients. Having an understanding at the outset about those expectations about experience can improve the value. Using communication as an example, many Gen Zs might not be expecting to communicate with you via email. Your client might have the expectation that they're going to be able to ring you 15 times a day. Managing those expectations will improve the client experience and improve the client's perception of value. Often, complaints about costs and complaints about value stem from those misconceptions or misalignment of expectations about the experience. A classic example is a client who comes to the partner, who's recommended to see the partner, sees the partner in the first meeting, but then the rest of their experience is with a more junior lawyer. There may be very legitimate reasons for that, but if the client's expectation was that they were going to be dealt with by the partner, that was who their point of contact was going to be, their feeling can be that they have not had value delivered because they were dealing with someone more junior. And then the last aspect is partly what we've talked about previously, personal benefits, but this is where brand image and prestige comes into play, or where what they are actually valuing is the industry knowledge or experience, the white hair, the authority of the individual who they're dealing with. There is a reason that large corporates will have top-tier law firms on their panels. It is a comfort aspect, but it's also often a brand aspect and a prestige aspect as well. Let's turn then to the elements of cost. And there's really 5 elements of cost. Monetary, the price, how much is it going to cost? The time that the client is going to have to invest in the engagement with you. The energy that they're going to have to invest. What's the level of their own personal involvement? Their psychological cost. How traumatic is the experience with you going to be? And then what's the risk of engaging with you? Have they made the right choice in choosing you rather than choosing another lawyer? As lawyers, we often focus on that monetary aspect of costs. But as we'll see, as David's about to talk about, cost is often the least important aspect of that purchasing decision.
One of the myths about economics is that clients always want the lowest price. It simply isn't true in most cases. And yes, I agree that no one wants to pay more than they have to purchase a product or a service, but not everyone wants the lowest price. In fact, some people will never pay the lowest price. Perhaps there are things that you purchase where you would never pay the lowest price because the lowest price suggests to you that that product or that service may not be reliable, it may not be of high quality. Usually, price is not the primary driver in our purchasing decision, although I accept that it will be a significant one. It was extremely helpful to me a little earlier this year when I heard a pricing guru from the States called Mark Stiving explain that there are actually 2 buying decisions that we make every time we purchase something. The first decision, he said, was, will I make a purchasing decision in this category? And if the answer to that question is yes, the second purchasing decision is, which product or service will I purchase in that category? What Mark says is that the first question, will I purchase in this category, is less price sensitive than the second question. There is more price sensitivity for us when we're deciding which product or service that we're actually going to purchase when we've made a decision to purchase in that category. So for us as lawyers, if by the value that we can create for clients, we can convince a potential client to make a purchasing decision in our category, we're already way out in front in terms of the opportunity that we have to outstrip our competitors. So it is a fact that purchasing decisions involve psychology. And here we have Mr. Spock and we have Homer Simpson. Mr. Spock is the ultimate example of the uber analytical being, always relying on data. And Homer Simpson is, I accept an animated personality, but he is a bloke and he makes decisions like a lot of other humans. Mr. Spock, Homo economicus, Homer Simpson, Homo heuristicus. And so what are heuristics? They are simply shortcuts. They're flexible techniques that we all make every day for the purpose of arriving at relatively quick decisions. And I make those decisions just like you. I hate shopping. I accept that I need to get milk and bread and cheese and a cup of coffee every day, but outside those purchasing decisions, I like to avoid going into shops, and I hate buying things for myself such as suits, but suits wear out and I know that occasionally I need to buy one. I have a very reliable vendor in my locality. He sees me coming and he sees my wife coming as well, because she always is with me when I have to buy a suit. Don't repeat this to her, but my wife is my heuristic when it comes to buying suits. And what the suit vendor knows is that I just don't like being in the store. I want to get out as quickly as possible, and I will make as many purchasing decisions as I can to avoid the pain of having to be there. He's built a relationship with me. He knows my psychology, and if I go in to buy a suit, I always come out with several shirts as well, often a pair of shoes, and I may come out with another suit. The psychology of purchasing is present with us all the time. As John said a little bit earlier, if our clients don't understand the value that we can create for them, then whose fault is that? And this slide has a lot of the tactics, I suppose, that can be employed when we're attempting to influence our clients about a pricing decision. We don't have time to touch on all of these today, but we are going to look in some detail about a significant opportunity which we all have in framing value and price for our client, and it is the power of options. Who would have thought that by providing options for clients, we can help our clients decide what it is they actually want and what represents value for them. All value is subjective. Value is like beauty, it is in the eye of the beholder. And sometimes as lawyers, we think that there is an innate value meter present in every client. That is a flawed assumption. It is simply not the case. Every client will assign different value to what it is that we can provide for our clients, and they need some help to assign value sometimes. And one of the ways that they can get help is by comparing one thing with another. Sometimes that thing that they will use to make a comparison is price, but price is only one means of comparison. When we can demonstrate our service offering to our client and the way we can address the client's problem by reference to a range of possible options, it is usually very, very satisfying for our clients. It gives our clients a sense of control. And that's very, very important for a lot of clients when making a purchasing decision. It can lead to increased satisfaction. If we only present one possible scenario for getting the client's problem solved or getting the client's opportunity realised, it's often the case that our clients will find it difficult to understand what the value is. And so if we can do that, not in isolation, it can be very helpful to our clients. Alternatives provide a reference point. And so if we can really get good at constructing options, it can be very helpful to our clients and assist them in making purchasing decisions. When we provide options, they demonstrate that we are actually creative. Are there perhaps 3 ways of getting to X? Options make our clients feel empowered. They don't have to take just the one proposal that we submit. If there are 3 options, they have the choice, and it is in our nature as humans to feel good about that. When we give a client options, often the question is not whether they will work with our legal practice, but they will ask, how am I going to work with that lawyer's legal practice? That can also be very, very powerful for a client. Finally, it helps us to flush out the client's expectations, and clients' expectations can be very, very important down the track. If we can establish up front what the client's expectations are, it will help us to understand how we might work with the client, indeed, whether this might be a suitable client for us. Options help to build trust and they demonstrate our expertise. And you might be thinking, how can I construct options for my client? Well, it's not actually all that difficult. The first thing that we have to do in formulating options is have a very clear understanding of where the client wants to get to, what are the client's objectives. This table has the objectives set out right at the top of the page, and that's for a reason. It's probably the most important part of the document. When we agree the objectives up front with the client, quite expressly, the rest of the project can usually flow very, very effectively from there. When we've agreed the objectives up front with the client, and then we come to sketch out the possible scopes and the possible prices, clients usually find that a lot more fulfilling because there's congruence between the scope and the objectives. And so in this scope and price proposal, it's for a telephone hotline service, and you'll see that we have built the 3 options from the gold option through the silver option to the bronze option. And the price decreases as we go down, and it's a well-established pricing principle that we should be presenting our highest price first. Under scope and price, there's a listing of some possible scope of work, and you'll see that we're actually offering more by way of scope under the gold option compared to the silver option, and more under the silver option compared to the bronze option. Another really important part of this scope and price proposal is that second bottom line about value. This is an opportunity for us to describe to the client what the value of each option is. Each option should be capable of delivering the objectives that the client is looking for, but they might be delivered in different ways. By setting up the scope and price proposal with these three options, it helps our clients to understand what it is that they're actually looking for. And sometimes a client doesn't know in advance what they actually want to achieve and what value that they actually want to take away. And so when we present a scope and price proposal in this formula, it can be very, very instructive for a client. That's one that I made up for the purpose of the exercise today. Here is another one that Liz and John and I have downloaded from the web, and it's a financial planner's scope and price proposal. I think they've made a mistake to the extent that they have started with our minimum price option on the left-hand side of the page, rather than putting their highest priced option there. But otherwise, it's a pretty good effort in enabling a client to understand how this particular firm of financial planners could work with clients in slightly different ways to deliver outcomes. The outcomes are all listed there. Effectively, the scope is described in very brief terms in those coloured boxes at the top of the page, and then in the middle of the page, again, under the heading Outcomes. The prices are there in the second top line, and there's a description of the ongoing work that will be done. The prices for each option, of course, are different because the scope of work is different and the value is different. This financial planner has missed the opportunity to actually describe the real value that the client can potentially extract from selecting each option. But other than that, it's probably going to be a very useful document for their client. This very simple option enables a client to see in quite stark terms the value that can be derived by the different options. It helps clients to understand that, yes, there is compromise involved often when they make choices about options, and the lowest priced option at $4.95 per month doesn't deliver all that much. It's only 5 gigabytes of email storage. With the middle option, there's 10 times as much email storage. And of course, with the top option, which is at a much higher price, there's not only the 50 gigabytes of email storage, but 1 terabyte of secure online storage, which might help the client avoid the need to store documents in Dropbox, for example. There is a compromise associated with choosing one or the other, and it's important for clients to make that, to recognise that, and that helps them make decisions. As Liz said earlier, in every purchasing decision, it's important that we help the client understand the benefits and help clients understand the costs. The costs, as Liz said, are not confined to financial matters or monetary matters. They involve time of the client, personal involvement, energy, and risk. And this is what can happen with unbundling of services. Sometimes when we offer clients options by way of unbundling the service, meaning that we will do less of the work and the client will do some of the work, or perhaps another service provider of the client will pick up some of the work, there are costs to the client. The client itself may have to do more work. The client might be prepared to assume more risk for the sake of a lower price. There are various ways that a proposal can be framed to reduce risk for client. And it's beyond the scope of this webinar for us to go into too much of the detail, but one of the things that I have found in my practice is that if we can give clients more certainty, the client will feel that risk for the client is being minimised. Another way to reduce clients' apprehension about risk is to provide a service guarantee. And often we can't guarantee an outcome, but if we've agreed the level of service that we're going to deliver to a client up front, we can give clients an amazing reassurance that if at the end of the project, their perception of the service that we've delivered doesn't meet what we promised, they can have a discussion with us about how that should be reflected in the price. That can be a great encouragement to clients. And so if we can encourage clients, we can actually build trust with clients. And when we build trust with clients, this can help us to do more work with clients. And if they're clients who are the right fit for us, then that can be incredibly profitable for us in the long term. There are various other ways to create options and give client choice rather than just talking about scope and price. One way is talking about timing. How quickly does the client need this particular service from us? Perhaps if they need it more quickly, the price will be higher. When will the client pay for it? If we give extended credit terms to the client, perhaps our price will be higher because terms are price. What sort of technology can we use to deliver the product or service to the client? There might be variations in price associated with the technology. Does the client want the product or service delivered by a partner in our firm or by a more junior solicitor? That might be something that influences price. How does the client want the product delivered? That can be tailored. Do they want it with all of the bells and whistles, or do they simply want an executive summary? And with transference, sometimes there are opportunities for us to share our knowledge in different ways with clients. And if we're prepared to do that, perhaps by running seminars for clients as a bit of an add-on, that might be something that convinces a client that the client is justified in paying a higher price.
Thanks, David. Choice architecture, and David's already spoken about that, about presenting choices, and we believe that if you present your top option, your highest option with the most benefits first, is a better way to go, because then your clients can see that they're what's being taken away. The choice is theirs. It could be a lower price, but they're missing out on some benefits. We all need a reference point about something, so it is so important to have some sort of framing. What would you pay for a unicorn? Oh, I don't know. What do you compare a unicorn to? So we do need to frame the rejection or selection, the order of presentation, which David spoke about. We talk about the paradox of choice. Too few choices and we feel cheated. And it's the one choice, which is really not a choice, of course, being imposed on a client compared to the client making the decision. We like the Goldilocks effect, which is the three choices. It just seems to work. We use that a lot in our daily lives, whether you're getting a tradesperson in, that sort of stuff. Too many choices can cause stress and decision paralysis, and we see that all the time. In a lot of day-to-day lives at the moment. Again, I just want to emphasize what David said before. When you offer choices, clients much more consider how they're going to work with you rather than whether they will work with you. Here's another example, the effect of adding a third premium option. You would have, I don't have one of these watches, but my colleague Liz Harris does. I'm looking at it now, or even an update. And there we have there the different prices for different benefits. And look what's happened, the effect of adding a third premium option. It makes those otherwise $329, who's going to pay $749 for a watch, no matter how good it is. But it looks a pretty good purchase compared to the $13.99 offer. And again, we're subject to these sort of options and choices every day, whether it's at the supermarket, airlines, hotel bookings, a lot of online, and increasingly we're seeing it in professional services. Anchoring. Again, it's used every day in our life by salespeople, advertising. We do it too, to ourselves, to our clients, whether we realise it or not. You're anchoring your client if you said something to them. This could cost you $2,000, or it could cost you $6,000 or $8,000 or $10,000. The mere fact that you have used $2,000 means you are anchoring your client to something, so that even if the bill comes in at $3,000 or $4,000, your client, and you've done it to your client, you've anchored your client to $2,000. It's very important. Now, anchoring can be, we don't have time in this webinar to discuss it, but anchoring can be used very, very positively. Car salespeople use anchoring all the time. I don't know whether any of you have been to this restaurant in New York. I haven't. But have a look at this for, if you look down, eggs Salent, the $1 zillion lobster frittata, $1,000, supersized 10-ounce caviar. I don't know how many people would purchase that. Presumably the odd sheik or someone does. But it's $1,000. But you can get the regular 1-ounce caviar for $100. And they sell a lot of those. But without that supersize $1,000, who in their right mind is going to pay $100 for a lobster frittata? Again, Liz will talk about selection and rejection.
We've spoken quite a bit about the way we lay options out. And as David and John have talked about, ideally, you start with your top option on the left-hand side of a page, and we should have said that it's actually useful, if you can, to lay out your options side by side, because we read, in Western countries, we read from left to right, and it is much easier to compare options if they are laid out side by side. The idea of your top option being on the left-hand side is tied to anchoring. It's tied to the fact that the first figure you see anchors you to an expectation about what the price is going to be. And therefore it makes the middle option look somewhat more attractive. The lower option on the left plays into what I'm talking about here, which is selection or rejection. Studies with participants creating pizzas illustrate this. So a group of participants were asked to actually create their own pizza. So they were provided with a whole range of toppings and a blank pizza base. Others were provided with the full pizza and had to make decisions to positively take toppings off. No one wanted to take too many toppings off. It's a positive decision that you have to make to actually take items out of scope, which is another part of the reason that we present our broadest scope on the left-hand side or first, because what you are wanting to do is to make clients make the decision to take something away. And this ties into another heuristic, which I'll talk about in a moment, which is the endowment effect. Once we actually have something, we don't want to give it up. Having said that, as John has said, there is that happy Goldilocks position in providing choices. That you don't want to provide too many choices, because otherwise we end up with decision overload. And there are certain clients, we will all have experienced this, where there gets to a point that it is easier to make no decision. Last night, I was sitting wanting to watch something on Netflix and scrolling. In the end, there were too many choices, and it was easier just to go back to ABC and the Gruen transfer, which I probably should have watched in the first place. So there is that happy medium about the level of choice, and it becomes in particular a trap for people when they are describing scope, that they become far too detailed in the scope decisions in their top scope. And therefore, each time you are taking something away, you have to understand you're actually making a client make a decision about that particular point. So again, a happy medium between a scope that is too complex and one that is sufficiently detailed that you then don't get caught out in scope creep later on, which is another topic. It's really interesting when you actually start looking at pricing options. It's like anything, you start seeing them more and more often, and you'll see them everywhere, on the web in particular, but in magazine advertisements and the like nowadays. And you will often start to see that one of them has been highlighted as the primary option. A classic example is going online on Qantas to buy an airline seat. You will see nowadays that there will be a particular option where it might pop up, 5 people have looked at this in the last half hour, or be quick, only 5 seats left. Part of that is that Qantas are trying to push you to that which is their preferred option. But we'll also see it in a moment in that just visually highlighting an option can direct the client to that one as being the primary option. Going back to the 3 options and tying in that aspect of risk, and often clients will actually choose the middle option because the lowest priced option creates an additional risk for them. It's part of the reason that in some instances we see a very low price for the 3rd option, because really they're trying to direct the purchaser away from that 3rd option because it just looks too good to be true. When we are looking at creating options, offer trade-offs. Don't offer trade-offs, offer complementary services. So in other words, you are adding to rather than taking away. An interesting aspect that we don't think about, and again it comes back to that perhaps tendency to think of all our clients as being like us in the way we make decisions, is not understanding that people are different buyer types, and we can be a different buyer type depending on the position that we're actually in, the purchasing decision we're making. We all know risk avoiders. We all know loyalty buyers. We all know bargain hunters. We all know price acceptors, who are people who really aren't too fussed about the price. They simply just want to go ahead and make the purchase. We know the indifferent purchaser, who needs to make the purchase and is more interested in convenience. I go and purchase my milk from 7-Eleven, albeit that I know that if I continued 5 minutes down the road, I could purchase this more cheaply at Safeway. Our clients will fall into different categories depending on what their purchase, the particular purchase is. This is a very common example that you see nowadays about pricing options. And it is a demonstration of what John was talking about with the omelette before, which is the decoy effect. Who on earth is going to pay $800 for a one-off use of this product? What this supplier would far prefer you to do is to sign up to either the monthly plan or the yearly plan. The reason why is you will sign up with your credit card and it will be debited on a regular basis. Monthly, it's on a monthly basis. Yearly, it's on an annual basis. And it's the trick with subscriptions that we probably all have fallen into. Particularly on a yearly plan, it's a one-off charge on your credit card that is renewed until you positively make the decision not to continue any further. Again, it requires the purchaser to make the decision. It requires the purchaser to take action to cancel the subscription. If you're like me, every so often I realise that I have been paying for subscriptions for something that I have not used for a very considerable period of time. It's a trap for us all. It's a reason why nowadays even car companies are looking to offer purchasing of cars by subscription, allowing you to update your car on a regular basis. If you work out the price, it's going to be far more expensive than buying the car less regularly than you would have otherwise done so. Many of us have fallen into that trap with phone plans and the ability to update our handset to a new model each year. But the other example, the other thing to look at in the way this has been laid out is the middle option is highlighted. Your eye is immediately drawn to it. It is highlighted by the supplier with the stars saying best value. Now, the reason this is best for the supplier is that yearly recurring payment, because it makes it that much more difficult for the subscriber to actually cancel the subscription, to remember to cancel the subscription. There's another aspect of the psychology of purchasing that as lawyers we can engage in, and that is the heuristic of loss aversion and endowment. Now again, this slide is another example of software purchasing, but you'll see on the left-hand side, the first option is free for starters. Probably some of you have fallen prey to this arrangement where it's free for a period of time, and then after that, you need to subscribe. And even if you don't have to actually provide your credit card details to start with, what this software is doing is allowing you to use it, to realise that you like using it, that it's helpful to you. Todoist is a task list program. Now you can imagine if you put all your tasks into it, you continue using it, you reach the maximum number of tasks that you can use, but now you're using it on your phone, you've installed it on your computer, you have possessed it. And you then have to make a decision whether you actually pay the subscription to continue getting the benefit out of it, and to make the decision not to do that creates that sense of loss. You have a sense of endowment because you actually have been engaged and you are using the product. It's the reason a lot of websites, a lot of professionals will offer you free products, a free book about something, ebook about something, a free white paper about something, because they are creating that sense of engagement with you, that sense of endowment. And it's something that we can utilise with our clients. We can offer our clients free information about their particular problem, and it creates a sense of trust with the client. It increases the likelihood that they will then retain you for the paid gig.
Thanks, Liz. So, sort of wrapping up a lot of this, it's why certainly in our world, and I know most of you would do it too, you know, having questions, particularly for a new client, but even for existing clients on a new matter, we call it having a value conversation. And you'll have your own questions, and depending on what your client, you know, who your client is, what industry you are, but, you know, questions like, what do you expect from us? How do you see us helping you? And what specific results do you hope we can help you achieve? How would you define a successful relationship? I know Liz loves that one in particular. How would you define success? One of my personal favourites is, you know, if price wasn't an issue, what role would you want us to play to help you? You take the price right off the table and get the client talking about, well, if you lawyers weren't so expensive, this is what we'd, you know, love you to do, or this is what we'd want to happen. You know, you're hearing it from the client because we've asked the question. And, you know, if we're half good, we can reiterate that back to the client together with options, but it's what the client has actually asked for. How important is this to you? I mean, we may think it's the greatest legal problem, you know, we've ever faced, but if the client's just seeing it, it's not very important at all. Or it may be the other way, the client sees it so important, yet because we've got our expertise, we're able to allay some of their fears, but again, because of our expertise and experience. Again, this is another one I like. Many, particularly institutional clients, they will already have a budget. And so sometimes you might have to ask, well, what's my budget for this? What have you set aside? So get that up front. It is quite, particularly on urgent matters, we find that, and particularly dealing with in-house counsel, they may already have a perception of how much they expect to pay for this. Then it's up to us to come back to them, perhaps provide the various options, and perhaps provide an option which has absolutely everything that they hadn't even considered, but they will pay a higher price because they're going to see a greater benefit that even they haven't thought about. How would we measure success? What are, as Liz spoke about before, the financial tangible costs and benefits? What else is affected by the issues and the solutions that we can hopefully help our clients provide? Again, some more of the value questions, and you'll have, you know, your own. We'll make these slides available to all of you, but, you know, how will your client's life be made easier and better? And what is our client's cost of not solving this problem? There may well be a dollar cost. What is the client's economic benefits in solving the problem? Again, there may be tangible economic costs there. Who on the organisational chart are we dealing with? Are we dealing with their money, someone else's money, shareholders' money? Can that person say yes? Or actually, can that person only say no? We see it all the time, and we've experienced ourselves. The person that we're dealing with actually can only say no. Are there time-sensitive deadlines? What are those? Can we affect those time-sensitive deadlines? And what do you expect from us? We've already talked about that. Communications, responsiveness, level of involvement, and level of support. And again, I think perhaps in the past as a profession, as lawyers, we've made assumptions that all our clients expect the same things. They don't. And it's up to us, by the power of questions and our experience in finding out just what clients, and then tailoring a service or a product that meets our clients' expectations. And we can influence our clients' expectations, absolutely. But as we spoke about right at the beginning of this, at the end of the day, it'll be your clients will have their own perception of value, because value is subjective. Little bit of an advertorial. We're running if you want more of this, there's a Transforming Your Day one-day workshop being held in Melbourne on the 12th of November. A Vera Sage Symposium, some of you may know about, being held in Geelong 2-day. There's a couple of seats available for both of those just at the moment. And at Innovim, we run a 4-month aligned pricing program, and our next pricing program's commencing in
late January,
early February 2020. Now, I think we may have some time for some Q&A. I'll be guided by Terry here as to whether we do have some time available. Terry?
Yeah, hello folks. We do have a little time available. We've also had some questions that have actually come in while you folks have been doing this amazing presentation, and it has been so comprehensive that you've managed to answer the questions in the course of the presentation. So thank you very much. Brilliant. Well done. Just watching that Q&A box now, but if I may, while folks are thinking about if they'd like to pose a question, just also mention some additional resources that are available through the Centre for Legal Innovation as well. John, Liz and David very kindly did a podcast for us. So if you'd like to hear this in a conversational mode, that will also be available to you on the CLI Collaborate or Click free resource hub. John also, I don't know how, but we managed to convince him to be a distinguished fellow for CLI this year, and he's very kindly also provided a short video and blog post on 10 tips and traps in this area as well. So folks, it looks like we are in a position to wrap. So I wanted to thank you, John, Liz and David, very much for your time today. We very much appreciate you basically making that time available. I see we have one question. I'm just going to read it to you folks. If we offer time to pay at a higher fee, does this not equate to interest and be unlawful?
I don't think there's any question that it is interest. I don't believe it is interest at all. Interest can only be an amount that's calculated on another agreed price. And if we're simply giving client an option to pay us $1,000 if the client puts the money in our trust account, and $1,200 if the client pays us in 60 days after we've completed the work, that is not interest. I hope that's a clear answer.
Thanks, David. And folks can always follow up with all of you as well, obviously, independently of this webinar. So with that in mind, I'm going to say again, thank you very much indeed. As you know, the Centre for Legal Innovation is all about these sorts of webinars. We've got lots more coming down the pipeline, very focused on presenting to you, as this one has, practical solutions to real issues in practice. Please don't forget to follow us on LinkedIn, Twitter or Facebook to get up-to-date information about that. And on that note, once more and again, most sincerely, John, Liz and David, thank you so much for your time.
Thank you, Terry.
Thanks, Terry.
And to everyone, happy pricing. And there's great nobility in being paid what you're worth. And if you're a good lawyer, you should be paid what you are worth.
Absolutely.
Thank you. Thank you so much.